on the application of Pearce and Parole for independent way.
Yes, Mr. Roy.
My Lord, if I may firstly introduce the parties, I appear on behalf of the appellant, learned friend Mr. Rylett. For the appellant, learned friends Miss Sackman and Miss Fegan appear for the Parole Board of England and Wales, as they did below, and Mr. Granderson appears for the Interested Secretary of State for Justice,
yes,
as he did below. My Lord, I think the message may have reached you, but Council were wondering whether it's appropriate we sit in this particular row.
As long as I can hear you, that might way you sit.
Very grateful, my Lord, thank you.
I can tell you that we have read the skeleton arguments, including your supplementary. We have read the judge's judgment, and we have all read BSD and Morris.
I'm very grateful, my Lord, thank you. So, my Lord, as the Court knows, this appeal against the dismissal of the claim for judicial review requires consideration of the approach the law requires to unproven matters that come into the decision-making of the Parole Board, and the consideration in particular of the adopted guidance of the Parole Board in recent years in relation to unproven allegations, and whether or not that guidance is consistent with the legal principles that are applicable. The question involves consideration of those legal principles establishing the authorities as to fact-finding and the requirements of fairness, and the appellant will seek to draw...
Fact-finding and what?
Fact-finding, and secondly, for the requirements of fairness, fair hearing, fair determination. It goes without saying, of course, the context of these decisions is often liberty, not in every case, but in the majority, and the guidance doesn't distinguish between them. The Parole Board panel will be considering whether or not to continue detention or whether to grant liberty to the individual. And so the context for decision-making, of course, involves liberty. It also, for the sake of completeness, involves Article 5.4 in the case of indeterminate sentence prisoners. Again, not all parole decisions, but some. But my central submission to you, and I don't envisage there'll be any difference in the submissions you hear, is that Article 5.4's requirements of fairness will be met if the common law's requirements of fairness are equally met. But it's right to note that it does engage Article 5.4 in the case such as this appellant, where the sentence is an indeterminate one, and as you'll know in relation to him, his sentence, the punitive term, had expired in 2013, so he was post-tariff in the expression, and only to be detained if the risk justifies it, as opposed to on a punitive basis. The appellant would submit this in outline before dealing with a brief summary of the argument that will be advanced, that the appellant's case does not require or mean a lesser protection for the public or a hamstringing of parole decision-making. The appellant's case, properly accepted, means for the Parole Board that there will be fair determinations in a clear and workable manner, equivalent to that which the courts apply.
A fair and what manner?
And workable.
Workable.
Yes.
And what do you mean by that?
So the ease with which one determines, if one moves slightly further forward in the argument, if the decision-making follows a course which is decide the facts that are proven to the applicable standard, which in this case, is no dispute, is the civil standard, using the available material, which in this case, no dispute again, can include hearsay material, so written material and other things, so long as it's being fairly dealt with in terms of the context. With all of that, make your findings of fact. What are the facts that you've decided exist? And then apply to that in a secondary manner your evaluation, your risk assessment in the Parole Board's context.
In most cases, I won't say in every case, what a court is deciding is what has happened and what legal consequences flow from what has happened. The Parole Board is looking at what may happen in the future if the prisoner is released, and therefore it is assessing the future risk. Now, there may of course be factual findings which are relevant to risk, but simply to say, well, it's got to do what a court does, does not distinguish between the task that a court faces and the task which is given to the Parole Board.
Well, my Lord, I accept in some instances that is a distinction that is good, but I would also submit it is not a distinction that is in every case, and I say it for this reason. When I turn to the authorities, I will submit on behalf of the appellant that the way in which the Parole Board goes about its task is to find those facts and then to take an evaluative decision on the risk assessment. But equally, courts often are faced with such a decision-making. Now, an example which comes up, in my submission, a valid analogy or comparable that is drawn in the DSD decision, the Warboys case, is between a criminal court having dealt with the found facts by jury verdict or by Newton hearing or whatever other means by agreement. It has a set of facts in terms of what the individual has done in the past that's been proven. It may have to apply that set of facts and add to that a fair determination of other wider material, which one comes to. It may have to apply a dangerousness assessment, if I use the shorthand, for an assessment of risk, future risk, that is posed by the individual that justifies a particular type of sentence being imposed at that point. So that provides, in my submission, a close analogy, because we're again talking about liberty, we're talking about future risk posed to the public, we're talking about public safety decisions in the evaluation. But the court has not, in my submission, suggested that in that situation the court can depart from the need to fairly decide what the facts are, albeit there have been discussions as to whether or not it's to a criminal standard or a civil standard, whether it's inclusive of hearsay material or not. But those issues don't arise for the present purposes, and they're largely probably settled in the authorities on those points. But so the analogy that we submit arises in relation to the task for the parole board is to clearly understand the two stages to the test. And we would submit that's, in essence, part of the difficulty in the judgment below and in Morris, compared to when we say cases like John, which wasn't cited below, but which we've included in the bundle. The distinction where the parole board does make findings of fact, and then it's separate decision-making about the assessment of risk. But it does that second task informed by the first. And what we say for the appellant is there isn't a grey area or a twilight zone where you take something that isn't a fact that you know is a fact and you factor that in, giving it weight in some non-specific manner. So that's where we say the unfairness arises, because what could happen...
So, I mean, are you saying that stage 2, the assessment of risk, is to be based solely on the findings of fact? Is that...
It's informed by the facts, yes.
Well, you say informed by?
Yes, solely on findings of fact, yes.
Added to everything else that's known. I mean, the fact that this particular appellant was made subject of one of the old IPP sentences. So he's well served his tariff, but it's now the responsibility of the parole board to assess future risk. And in those circumstances, the parole board surely starts on the basis that the court had made a determination in nowadays would be dangerousness in accordance with the Civil Justice Act. We have to look at all of the information that's put before us, unless there's a good reason to disregard it. And on that information, we must draw certain conclusions, if we can, and then you say, they go on to say, in having regard to the whole, yes, we then go on to say, what is the risk now to the public? Is it an acceptable risk?
Yes, whether it's necessary to confine. And my lady, I think if I clarify what I said earlier, the facts, I'm not drawing any particular distinction. What are the facts? It's all of the facts. So the information that isn't challenged, that's available, plus anything new that you're actually resolving for the first time. It's all part of the relevant factual basis for your evaluation of risk.
So it would include the reports, everything before the parole board.
Exactly.
And can I just make sure that I understand your skeleton correctly? You do wish to distinguish, I think, between facts that can be found even if it does not lead to a finding that a particular allegation is proven to the civil standard.
Yes.
So in Mr. Pearce's case, you would accept that the parole board could, for example, find, well, we find as a fact that he was in the company of two young girls who happened to be half-sisters. We accept as a fact that as a result of something that caused concern, he was arrested. We accept as a fact that he admitted being in the presence and that games had taken place which may have been misconstrued.
Yes.
This is not on the facts, but I'm just suggesting that they are facts which may still not lead the parole board to saying, and therefore we are satisfied on the balance of probabilities that he sexually assaulted them.
Yes. Yes. One caveat to my lady's list, but in general, the principle is the principle that I advance. Yes.
Yeah.
The one caveat is the arrest. One has to be very careful about any assumptions or value or inference that comes from the fact of an arrest. So that can be.
So it's got to be an arrest for due cause.
Yes. So the being in presence found as a fact, probably what happened because it was in the report or it's admitted, that sort of thing. So whatever surrounds an arrest might be a fact that you find, but just finding as a fact you were arrested at some point would not be sufficient in my position. It would have to be
the old situation of arresting all known suspects who've got the modus operandi would not be sufficient.
Exactly.
But if there was due cause, even if that due cause upon subsequent investigation did not lead to a prosecution, for example.
I think one has difficulty, and we are talking in a generality, I appreciate.
Yes.
But an arrest in itself, if one accepts the principle that Broadbent informs us, a mere fact of a charge is not sufficient. You have to look beneath it. What has caused that? What is the evidential basis for the arrest or the charge? And the parole board is entitled, of course, even if a charge isn't proceeded with or a case doesn't go to court or it's an acquittal, they can still, if they can act fairly, gather the material, consider that, and make their own findings at a different standard of proof. So they would be able to say, well, that wasn't proven to a criminal standard, but we find that fact, that you did this action, or that omission rarely, but usually the action that's alleged. We find that that's probably what you did, because we've relied on this piece of information or that piece of information that we regard as reliable, sufficient for us to make that finding a fact.
Yeah.
But in all that approach, what is happening is the information is being gathered, and the parole board is making a finding of fact about it in order to inform itself about what that tells it about the risk posed. So in my lady's example, who you've chosen to associate with, where you've been, what you've done that's been proven to be probable, those things are all relevant to then go into that second stage where we're factoring what do we make of that? What does that tell us about the risks? Even
if those facts do not lead to
Absolutely.
a conclusion of
A
a
particular
criminal
offence.
act. Yes.
Absolutely.
Okay.
So the appellant submits that it is a novel approach that the parole board advocates in this case, that it can make something of what is described as an allegation, what amounts to an allegation, even where there are not facts that go to inform the risk assessment directly, but nonetheless to have what it calls a concern over the unproven allegation. And the appellant submits there is an important dichotomy between what is a fact and what is not a fact when one comes to consider what one's doing with that in the decision-making process.
So in Morris, for example, the parole board are entitled to find as a fact that a heated altercation took place between the prisoner and his wife. They can't go any further than that and find that there was any criminal offence committed, but the fact of the heated altercation is a fact which they can take into account in assessing risk.
Yes, in the sense that in that case it was accepted there was a verbal argument. So they have a fact there, they can find that's probably what happened with no real difficulty, it's agreed, and then make what they wish of that in terms of a risk assessment. What does it tell them? Is he in that relationship still? What was he doing? Is there a culpability? It doesn't take you very far, I think, in that example, because one doesn't gain very much from that fact itself in a no longer extant relationship. But what you cannot do, and which Morris, in my submission, falls into error in doing, is draw from that there was violent behaviour, which is the words they use later in the judgment, because you haven't made a finding of that fact. I mean, you might have done if you'd obtained witness statements and said, we prefer the witness to what you've told us, and we feel we've given you a fair chance to answer that allegation. But you can't just skip that process. You can't avoid not only the rigours of a criminal trial or a civil trial in terms of disclosure and court process and representation, other things, but you can't just avoid having to decide what the facts are when it comes before you as a parole board. There's still at least the requirement to reach a civil burden decision on whether those facts happened, whether that's an actual fact and therefore something should carry against the individual in the risk assessment.
But in the case of Morris, the fact that he was involved in a heated altercation with the victim of his previous crime could be used in a risk assessment legitimately to indicate that, first of all, he's got continuing anger control problems and that he is not keeping away, if there's an injunction, for example, from his former partner. That would be perfectly permissible as inferences to be drawn from the facts.
Yes, it would be
that found
your behaviour that you would draw that risk assessment from.
Yes.
In Morris, it's a slightly difficult example for me to accept because, you know, I appeared in Morris and I know that he actually denied it and said he was assaulted by the gentleman, and that's what the allegation was about. But on a factual example, one could certainly do as my lady suggests, and make.
But it's got to be explained by the parole board.
Yes, they've got to say, well, we've found as a fact you were in a heated altercation, and that tells us this information that's relevant to your risk. That gives us that extrapolating from that the inference of risk, or the information about risk from that fact.
So from the collateral facts, you can make an assessment of risk.
Yes.
Yes, and you accept that.
Yes, and the value of those collateral facts will obviously be fact specific, depending on to what extent they inform you of a relevant risk.
If you take an allegation that some offence has been committed, sexual assault or whatever it is, you may say, well, we can't go that far, but we can say, as my lady said to you earlier, he was in the company of two young girls, he did do this, he did do that. Whether there was a sexual assault involved, we can't say, but we can. So we're breaking down the allegation into its component parts, in other words.
Yes, all the individual facts that are given this tight description of allegation, if individual facts are found, they are found, and so you can rely on those to whatever extent they're relevant. Obviously, in some cases, those facts will not actually, unless there's an offence added, unless they amounted to the allegation, won't actually tell you anything relevant to risk. So it depends on the circumstance. But there will be cases where because we're talking always about allegations, or in the context here, we're talking about allegations before someone's committed the index offence and been in prison. So using the appellant's example, we've got offences dating from when he was either 13 through to 21, most of them about 19. He's then 38, 39 being considered by the parole board. So we've got the conviction offence. We know what he's done in terms of the conviction, 2 serious offences there. We have the previous conviction, so we already have a lot of information that informs our risk assessment of him. And then we have what work he's done to address those risk factors. So the question is, does the facts that you're finding about earlier matters add to inform, give you more information about those risks that alters the position? And when we come to it, obviously there is a dispute between the parties as to how often it's necessary or appropriate to engage in this whole fact-finding exercise, where you have risk factors that are known depending on the level of it. Now, that to an extent, what is the line for exceptionality or not, if I'm right that it's not every case where you have to do it. The central submission that the appellant makes is it's about whether it adds materially relevant information. So if you already know all the risks, then there's no real need and no public protection basis to go back to trying things that haven't been tried without the information or the rigours of a criminal process or even a civil process. So when you need to do it is a question, but once you've decided to do it, that takes us into the questions of how you do it and what you make of the facts you find. And that can be collateral facts as well as full allegations. And it might be that you've regarded the allegations potentially informing you of further risks if you find it. But if you haven't, you'll then look at whether the collateral facts you can find give you that risk assessment or not. And if they don't, you'll disregard it.
Before we get there, just thinking at the moment of Mr. Pearce, he underwent a PIPE,
psychologically
offender
informed
treatment program, and he was recorded to have done very well.
Yes.
Now, in this particular case, are you suggesting that it was not necessary for the parole board to say, right, well, we, the parole board, have the responsibility to determine risk, not the psychologist. We take into account what the psychologist said, but it's the parole board's decision. It's perfectly proper, isn't it, for the parole board to have said, well, Mr. Pearce, what do you say about these allegations in order that we can assess just how far along the programme you have actually travelled? And in those circumstances, to find that he had, they said, selective memory recall, and I'm paraphrasing, was significant. That's perfectly proper, isn't it? Once they'd found the facts.
If I step away from this case as an example, if it can be done fairly, there is nothing improper about using the material to test the individual. The reason I step away from this case for the moment is because they didn't obtain the material upon which to fairly test him and look at it. So there is no, when one deals into the detail, there was none of the material that identified why was this not a conviction, why was it not charged.
No, hang on a second.
What was the information?
I think you're jumping the fence before it's put before you, really. In this case, whether or not there was sufficient information that could have led to a finding that a sexual assault occurred, taking the example of the two young sisters, wasn't it proper for the parole board to say to Mr. Pearce, Mr. Pearce, there is a complaint that was not proceeded with, but there is a complaint that's still there that you sexually assaulted one young sister and attempted to do so to the other. Now, what's your response to that? Asking for the response to the allegation. And if Mr. Pearce says, well, I can't remember that, isn't it something that the parole board is then able to say, well, we found his response to be either deceitful, because we cannot accept that he could not recall it and he contradicted himself subsequently, or, I mean, that's an important fact, isn't it? And it doesn't need any information to be put before them in terms of prosecution advice on charge or police reports.
Well, the difficulty with this in my submission is this, that if you haven't bothered to obtain, or you haven't been able or tried to obtain the material that would enable you, that you would do in any other situation, where the individual would be told, this happened 20 years ago, this is the record of it, this is the name of the person, where it was, etc. Tell us what you remember about that. Instead, what we have in this process is an individual who says, and we cannot judge to what extent it was right or wrong in the process adopted to say we regard this as minimising or we regard this as deceitfully not answering. But in that context, we know procedurally how it's happening. He's being asked matters which, if we leave to one side the right against self-incrimination, which causes a bit of an issue because you're damned if you do or don't in some ways, which, because we have the right not to self-incriminate, is an issue. But if you put that to one side, just simply on the procedural basis of asking someone, do you remember something from this period of time, and whether the right date was put to him or not, because there's a 2005 or 2003, or 2002 rather, record in relation to a 15-year-old girl that's in the records, and that's recorded as 2005 at places, but actually it was corrected to 2002 in one of the police records, so in the same place. So how it was put to him, was it a fair opportunity to be able to remember, or was it deliberate deceit? And if you're asking about a number of things which have the potential in someone's memory, either because of the passage of time or because of their lifestyle at the time and whatever other factors they're involved in at that time, but all these things to make it realistically very difficult, if not impossible, for them to actually recollect these matters, even if they want to be open and honest, having completed all the work they've done and having sort of said, okay, I'll make a clean breast now of things. So the two things in my submission do have to be conjoined in terms of what we need to do to fairly go down that route of testing. But in a practical sense, the idea of using the information you've gathered to test is obviously something you can do, provided you're being fair in the way you do it. So that's the sort of litmus test.
Yeah, I see how you say it.
Yeah. So as opposed to the claimant's, the appellant's case, that there must be the ascertainment of the facts and then the application of those to the particular test that's to be applied, in this case the Section 28 test or the test for transfer to open conditions. The Parole Board's skeleton in this case reveals that its argument, as its guidance would confirm, is that the assessment of an allegation is not limited to relevant facts that have been found, i.e. the collateral facts within that allegation or others, but an allegation that is not regarded as, quote, bare allegation or lacking in any factual basis whatsoever can still be relevant and can still be given some weight. So to an unproven allegation is attributed such weight as it considers appropriate. This is on the basis that the Parole Board acknowledges that in not all instances is it possible to fairly find facts, which would be encouraged at an earlier stage of the guidance. But rather than regard that as meaning that the matter must be discounted, the Parole Board argues that you take that into account despite the fact that it is not proven on the civil burden. And the Parole Board raises that if one doesn't do this, potentially relevant information would be ignored because it cannot be proven on the balance of probabilities. But in my submission, the word relevant is legally relevant. It's material, it's information of what actually happened, a fact you found probably did take place, that you are then applying.
So if the Parole Board comes to the conclusion that an event probably did take place, but it's equally probable that it didn't, then it must just put that out of its mind completely when assessing risk?
The equal probability would suggest that it does not pass the more probable.
Yeah, indeed.
Yes, and so it must be.
Even though there's a 50% chance that it happened?
Yes, if you cannot fairly determine that it did happen, then I'm afraid that is the legal consequence. Because the court and the Parole Board equally cannot be perfect, we have to operate a system by which we find facts the best way we can, which is both procedural and fair, but also in terms of how we then approach that. And already we are setting the bar in my submission not particularly high, where one talking about potentially criminal acts that have not been prosecuted and subjected to the rigours there, or have been acquitted, but are still going to be held against your liberty in this on the balance of probabilities. So in my submission, it's not an unduly onerous task or threshold, and some might argue that the threshold is relatively low, and that's why there was originally the debate as to whether it should have been the criminal standard the Parole Board was applying.
Can I just try and make sure I've understood what you're saying is permissible and what isn't? We had the example of somebody who has been in the company of a number of young girls, and that's a fact that occurred, and just a number of other facts relating to that series of events, all of which I think you said, if established to the civil standard, could then be used in a risk assessment.
Yes.
Right. So let's take that set of facts, but let's assume that the Parole Board can't say, on the balance of probability, that an offence was committed. Are you saying that they therefore must disregard completely the possibility that an offence did occur when making their risk assessment? Or can they say, well, we know all the surrounding facts occurred, we can't say that there is a 51% probability of an offence having been committed, but we can take into account the chance, say 40%, say 30%, that an offence was committed. I don't understand the line that you've just drawn, because I thought you said they could, in making their risk assessment, take into account all those facts. Well, the risk assessment is purely that he committed an offence. So I don't understand how you draw that distinction.
We submit that you cannot have it both ways. Once you've decided that in order to be fair, you have to establish what someone's actually done, because otherwise we are looking at smoke without fire. We're looking at, if it's less than a 50% chance, it's a possibility. Maybe you did, maybe you didn't. Well, how do you deal with that? You assume against the person that they did it. There's no other way of risk assessing.
But the risk assessment that you said could be done on using the series of proven facts, i.e. presence, etc., etc. What is that risk assessment? Isn't it the assessment that in a situation like that, this prisoner will commit an offence?
No. So it's an assessment, for example, has your conviction record not given us the full picture that in fact you seem to spend your time with young girls? Whereas from your conviction record, we had other offences, violence, let's say, but actually the non-conviction record, if we find as a fact that you had let's say it's a sexual record, but without the interest in younger females that might be revealed by the non-convictions. The fact that there's no offending with younger females, but that there may have been 3 instances where he was in company with the younger females, might take you in a risk assessment way to saying, was it appreciated that there may be a risk factor to be looked at in the treatment programmes in the last 10 years that looked at any interest in underage children? If there wasn't, because the conviction record hadn't given you that, but in fact we found as a fact that there was an interest in younger females, we think that's a risk factor that hasn't been addressed. So in the risk assessment, we're now concerned that actually the facts we found give us some more insight, give us this additional information that enables us to say, well, actually, that's a legitimate concern from the fact that that's a risk that hasn't been addressed. Whereas what you cannot do is say, well, we're going to take account the 20% chance that there's an offence here and somehow add that into our overall assessment. Because firstly, it's not fair, but secondly, it's simply impossible to do. You are going to, in your mind, work in a binary sense.
Sorry, break that down. You say it's simply not fair. I mean, sorry, can you give me
Well,
a framework for fairness?
You're holding against someone something that just simply may not have happened.
No, you're making a risk assessment.
But on what basis? On a possibility rather than on a fact.
Well,
so risk assessment.
Your fact is simply a possibility of more than 50%. I mean, you ascribe this sort of magical label of fact to something to which you can ascribe a 51% probability of it occurring. And you say, and this is building on the point that was put to you by Lord Justice Lewison, that as soon as you drop below the 50%, it ceases to have any effect. So you have a very bright line at a 50% threshold. Over it, you can take it into account. 1% below it, you can't.
Yes, but that is how all judgments,
it's how all decision making, when you're assessing what happened for the purpose of deciding what the legal consequences are, works, because you have to decide facts. You have to set a framework, decide the facts on the balance of probability, then apply a legal test. But going back to the point that was made earlier, when you're assessing risk for the future, why is there a bright line in the middle of the risk assessment?
Because you have these 2 stages that have to be separate. And I think my Lord's question to me is putting the 2, eliding the 2. If I put it in this way, that you have the fact finding, which is on a burden of proof, is on a balance of probabilities. Risk assessment is not. Risk assessment is not. You have over here. You have the fact finding with the balance of probabilities. So the probable this happened or it didn't happen. From that, you then inform the risk assessment, and the fact finding is going to be of a past event. This is not talking about the evaluative assessments of what you make of a past event or what you make of the prisoner's attitude that you've assessed, etc. This is essentially going to be, and when we turn to the John case, it seems accepted that generally one's speaking about fact-finding in terms of matters that have already occurred, that are past events that you are assessing, did that or did that not occur? And to that, we do apply a bright line, as it were, as bright as it is, but we are talking percentages when in the real world, we're talking about what I make of all the information I've received. Do I find it probable this happened or not? So that task, which does, and I accept the most difficult example, although in practice may not be that frequent, is that it's equally probable either way, and therefore you're in that 50-50, which I accept is where the line is. But in most cases, you're going to be able to resolve that with further information or with the application of
it's
inference.
not many decisions, is it, where you say, I'm really just not sure
Not sure.
right the
No,
way.
I'm 50-50.
Because, I mean, realistically, you're going to be saying it's more likely it happened. You don't say,
Absolutely.
I'm 51% sure or I'm 50.5% sure. You say it's more likely that it happened or not on the basis that he was with the young girls, he was 19, they were 3. What was a 19-year-old doing with a 3-year-old? Because it wasn't babysitting, et cetera, et cetera, et cetera. And quite clearly, it's not the risk of committing the offence, because you don't have to commit an offence to be a risk to the public,
Indeed.
do you? So it's the risk that the collateral facts could predicate on the basis of your past conviction, which has led you to being in prison. That's the fact.
Yes, the future risk is about future offending, of course.
Yeah.
Serious harm to the public. the present assessment is informed by all your past actions and the current assessment of you. And those past actions will include the convictions and any other facts that it is necessary and relevant to find, and that can be found as facts, probably occurred. And you then take that all forward to the risk assessment. So in terms of probabilities, yes, that's the theory, but you have made that decision, which is a real-world one, as to this is an allegation made against someone. If it's similar to their previous conviction, there's always going to be a starting point, which is not particularly on a common sense basis
But
until you look at it in
isn't the
detail.
difficulty, Mr. Earl, and I'm sorry to cut across you, that you know we're talking about facts and allegations, and really the allegations have been, I think, confused in some of the judgments of the Divisional Court, and also in the skeleton arguments, if I may say so, with allegations that would lead to a criminal prosecution. It's the facts around a certain set of circumstances that may feed into an assessment of risk.
Yes. Well, that in my submission is the appellant's case, that you can take all the facts that you find, and all of those are relevant, if they're relevant, but all of the relevant facts you've found go into your risk assessment. But what you cannot do is say, okay, we stop at stage 2 of the guidance. We cannot find facts of any kind around this material, whether we describe it as an allegation or it's just a fact. But we can't find that fact, but we're going to have a concern about it because it exists. There was an allegation, there was someone had said something, or there's a record somewhere, rather than we found that's probably what happened, and then we're going to take that into account. And
so you support Andrew Baker J's?
Yes, in Delaney, yes.
Yeah.
And
I mean, part of the problem comes from the ambiguity or the uncertainty in the word allegation.
Yes, it does.
So if you allege X, there may be 5 building blocks before you can reach the conclusion X. Yes. And you say, well, the parole board can find building blocks 1 to 4 as having happened, but they can't find building block 5. So the allegation is not proved,
yes,
but the building blocks 1 to 4 can be used in assessing the risk.
Yes, exactly. Yes.
So in other words, you've got to break down the overall allegation into its component parts.
Yes, but another way of doing that is to generally avoid the word allegation or the description allegation and deal with facts. If you can find a certain number of facts that, if you'd found more, would amount to a criminal allegation or a criminal offence, but they amount to telling you information. These amount to facts we know about the individual.
We find he's been hanging around outside school playgrounds.
Exactly.
You
now know this
we
fact.
can't go further than that, but...
Yeah, exactly. So so long as you have a fact that is of relevance, then you take that into account. But because there has been an allegation, if you haven't gone so far as to find that's probably happened, then the right thing to do, the fair thing to do, is to say, well, we don't know if that happened or not. We put that to one side. We deal with what we know. We deal with these 4 blocks, and we take that forward. So that's essentially why we say that the third way in the guidance is not necessary, it's not lawful, and it's actually confusing because you get into all sorts of difficulties about the description and the nomenclature detracting from a simple exercise of finding the facts that you've been given, and what does that tell you about risk.
Yeah.
And so just to complete the dispute, as it were, in outline, the parole board's case, of course, relies on a standard of proof that is shorter than that of probability and relies to that extent in the dicta in Morris on a significant chance short of a probability that an allegation may have happened.
Sure, I've just looked at the authorities, and nobody's referred to B in the Supreme Court, which is a Children's Act case, of course, but it's all on findings of fact on the balance of probabilities. And it may be thought useful to look at that over lunch if necessary.
My lady, I'm grateful, yes. My learned junior will no doubt find that for me, and we can
Yes,
hope to assist.
I think there are lots of ABs. This is a Lord Nichols speech.
Yes, Supreme Court.
My learned junior is very grateful. Thank you, ma'am. And so the Parole Board had set out that stall, as it were, in contradiction to the appellant, and defends appeal grounds 1 and 2, but is technically neutral on grounds 3 and 4, as my lords and lady know. If it finds favour with the court, I propose very briefly to deal with the essential statutory framework, which one can essentially take from the judgment below, then look at the jurisprudence that deals with the principles that we've been discussing already hitherto, the decision below and the guidance, and then address you shortly in relation to the grounds of appeal that arise and the particular parole board decision in this case, so far as that then arises. If that's acceptable, in relation to the statutory framework, you have that essentially within the judgment below at page 110 to 111 of the core bundle.
Yeah. You can take it, we've read this, of course.
Indeed, my lord, and in essence, I don't believe that I need to take the court to the materials other than where they're set out here. There is a slightly longer reference. Oh no, it is included here as well, so I was going to say Morris had slightly more, but no, it's here. So you have section 28 set out at paragraph 8. Obviously, that's a relevant statutory power for the indeterminate sentence prisoners, as opposed to IPPs and life sentences. There is another referral power, section 239, for other cases that come before the board for those on determinate sentences who've been recalled, for example, in other situations. And for those who are not yet ready past their tariff but are being considered for an open condition recommendation. So far as section 28 is concerned, paragraph 8, that requires the board to be satisfied it's no longer necessary for the protection of the public that the prisoner be confined. We haven't included detailed case law on that test, although it's been subject to detailed consideration. But there is authority that this doesn't impose a presumption, as it were, of any kind. There isn't a starting point, but and that's the Lichniak case 2003 1AC 903. But it doesn't arise as an issue in the case, but I make the point only generally that the board is tasked with reviewing all the information it receives and deciding on whether or not to continue the legality of detention based on an assessment. It's necessary for the individual to be confined for public protection.
Yeah, we're more concerned with the direction the board must consider any other oral or written information.
Indeed, so that's section 239, and that is, if one parks it for now, but we'll come to it, the McGettrick decision of the Court of Appeal that had a look at that and regarded that as being subject to the requirements of fairness. So the board is entitled to say, well, actually, it isn't fair for us to look at that material. We will not look at it. That's the extreme. That's actually removing it from the dossier. So McGettrick is a Court of Appeal judgment that allows the board to say this should be removed from our dossier. But short of that, obviously, you have the board saying it's not fair for us to act on that information, so we disregard that material or we disregard that allegation, if it might be. So you have the sort of the more ready version where a panel says we just can't take that into account. We haven't anything satisfactory about that. You have the extreme version, which is to remove it, and another panel will now consider the case, which is McGettrick. You also have Article 5.4, which doesn't, as I've already submitted, add materially to the common law requirements of fairness, but does, as the Parole Board guidance that we can come to in relation to oral hearings notes, require that there be appropriate adversarial safeguards in the Parole Board's process.
Yes.
There's also, in relation to the Parole Board's powers, the Parole Board rules, which refer to hearsay, essentially, because it refers to information. That's in the current Parole Board Rules 2019, Rule 24, subsection or subrule 6. That's not in dispute, and again, that was looked at in DSD and referenced in Morris, so the court will have seen reference to that. So no dispute about hearsay. You can look at the information provided you're doing that fairly. Then, as I say, there is the Parole Board Oral Hearings Guide, which is perhaps something the court won't have picked up from the pre-reading. Could I just invite your attention briefly to that? It's in our supplemental bundle. begins on page 2.
What's the status of this?
So this is an extant guide from the Parole Board, which is titled the Parole Board's Oral Hearings Guide.
Oh, yeah, but what is it in terms of what's its legal status?
It's published by the Parole Board for use by its members in terms of guidance. It's guidance. It's not. It's obviously not law as such. But my lord, in my submission, there's nothing that I submit is incorrect, as it were, about what I draw attention to from this guidance. It's more a pleasantly shorthand way of looking at the way in which the board deals with oral hearings and Article 5.4, and also hearsay. So, firstly, on page 3. You have there the inquisitorial or adversarial question, and the board in this chapter 3 to the guidance dealing with that there at paragraph 1, noting towards the end of that paragraph, speaking of the need for adversarial proceedings to satisfy the requirements of Article 5.4. And then the next paragraph, the reality most reviews and hearings contain elements that are adversarial and inquisitorial, etc.
Yeah.
Dealing with disputes of fact and potentially adversarial process for that.
And do you accept that this is Article 5.4 compliant?
Yes, if the manner of the Parole Board acting complies with the requirements of fairness, then it will...
and this guidance is compliant?
Yes.
Yeah.
And the other relevant passage from here... the other passage just below, the first couple of lines refer to the disclosure of the Secretary of State's written evidence. But that,
Sorry, where are you reading from?
Sorry, I think I didn't take the court's attention to the third paragraph on page 3.
Notably, the Secretary of State.
Yes, is required to submit all written evidence to the board he considers relevant.
Yeah.
So it's just in the usual way, the court will be familiar, a dossier is provided that discloses the material, and the process takes place often with a legal representative, subject to public funding, which was discussed by the Court of Appeal in the Howard Lee case. And then hearsay is another matter that comes out of this guidance. If one goes through to page 6, please, of the supplemental bundle.
Mm-hmm.
There's reference to 5.1 hearsay. It frequently receives evidence that would not be admissible in a court of law because it's hearsay. That might be slightly outdated in terms of our modern court practice, but nonetheless, it discusses the entertaining of hearsay evidence, but how to approach it.
Yes.
So the slight caveat I might advance to the guidance is just in relation to that last sentence there, the need to assess the facts and risk against the right of a prisoner to a fair hearing. That could be read in two different ways. If it's read to say that one cannot have a fair hearing but conduct it that way, that wouldn't be right. But I read it rather as the opposite, that one is looking at these matters, ensuring a fair hearing in the course of how you deal with them.
Well, it's giving actually a steer to the board quite properly that, you know, when we get to multiple hearsay, you're getting less and less from the source.
Exactly.
So this is all in the prisoner's favour.
Yes, indeed.
Yeah.
Indeed. And in my submission, it's correctly doing that because of the risks that we know, and the guidance, the court's rather judgments in the parole context are consistent with what one would expect in other contexts where one looks at hearsay. The usual approaches and cautions apply to that type of evidence as opposed to live evidence or witness statements that are direct, even if they haven't been cross-examined, and that sort of material. So we have that those common themes, as it were, the court will be very familiar with on the risks to some forms of evidence. If I may leave the legal provisions at that point, as I say, a brief introduction to them, but fortunately relatively self-contained in this instance. Rather less self-contained are the principles that one can take from the case law, but in my submission it's important to recognise those which apply for the purposes, firstly, of fact-finding and the fair process. So under that heading, if I may, there are some cases that I would draw attention to. And if I may just pause by way of repetition on the point that in my submission what the authorities don't support is that there is something unique about the Parole Board, different to the way in which a court would conduct an exercise of fact-finding and of application of a test, a legal test, including a risk assessment test, to the facts that they have decided upon. So the first authority, if I may, is the case of Brooks, Court of Appeal decision at R tab 8. This was a case concerned with the parole board, concerned with a case where the board had made findings of fact, but the fact that it had done so without the witness to an alleged complaint of rape, having been required to give evidence and be examined at the parole board hearing. So it's not a case in which there was a failure to conduct a fact-finding exercise. It's concerned with the way in which the fact-finding exercise is undertaken. And the parole board had before it, as one can see from paragraph 6, a witness statement that the police had taken from the complainant. So it had direct hearsay, as it were, in the form of a witness statement.
Yeah.
So you'll see that at the beginning of paragraph 6. And her attendance had been directed, so the board had in fact decided that it would be useful because she had been spoken to by the offender manager with inquiries made and a visit, and so that's at paragraph 10, I think, in relation to that. There were discussions, and then the direction at paragraph 11 that there be attendance is referred to. So the attempt had been there originally to have the individual cross-examined on the material, and then it is noted in the judgment that no party sought a witness summons. The parole board cannot issue a witness summons, but the parole board can request one from the High Court, as can the parties. And it's noted in this judgment that there had not been any attempt to witness summons on the part of any of those bodies. And so if one goes through, the court was divided as to whether or not it was fair to proceed in the absence of the witness, and comes down in the majority in it being fair in the circumstances for the parole board to have made the findings of fact that it did. And that's dealt with later in the judgment. If one goes to paragraph 37, which is in the judgment here of Lord Justice Kennedy, it was a circumstantial question as to whether it was permissible to proceed without the cross-examination.
So what's the principle that you derive from this case?
About fairness. So this case decides that in order to take into account the material, in this case the hearsay witness statement, you have to act fairly in terms of your process, and then you have to make a finding of fact about it.
Yes,
so
but paragraph 37 is saying it's going to be fact-specific.
Yes, but
as to what fairness is.
Absolutely, and that must be right. I accept that principle, but equally in my submission it's important that the board has to act fairly when it's dealing with an allegation based on hearsay material, or facts alleged on the hearsay material, and that it takes into account that process in the way it goes. But you'll also find, my lady, that the dissent, as it were, is 66 and 67 in relation to Lord Justice Clark's view as to whether that was fair.
He dissented.
He dissented. Lord Justice Wall did not dissent, but one can find, if one goes through to his judgment, begins at paragraph 68, but particularly through to 78.
Yeah, 72, he says, doesn't he? Board is to assess the evidence, give it such weight as is commensurate with the board's assessment of its reliability. Now, he's talking about hearsay. He's not saying you've got to find that it's proven. He's saying, here you've got a piece of hearsay evidence, you give it such weight as you think fit.
Indeed, in order to then reach your factual conclusions. And so that's the
Well,
importance.
in order to reach your conclusion about whether the prisoner should or shouldn't be released. Where does he say you can only do that in order to reach your factual conclusion?
If one goes to 78, in my submission, they're not inconsistent. What he's saying is how you get to your facts. In terms of the fair process, you get to your facts at 78 to decide what facts were established on the balance of probability standard of proof test.
He refers to Lord Nichols in H, I think it is, rather than B.
Oh, well, read B. I wasn't going to contradict my lord, but in fact I think it's...
Re B, is it? All right.
The children's case is re B.
Yeah.
I don't think it was Lord Nicholl, but there we go.
Great. So, my lord, I do place reliance on 78, which is what you do after you've taken the hearsay into account fairly, evaluated it as hearsay, given it weight that you attribute to the hearsay, you then make your finding of fact and then go to your risk assessment. And so he talked also of findings, his lordship, at paragraph 86, because she was essentially a hostile witness at that point.
In this case, though, I mean, I don't think this really helps you, does it, Mr. Orr? I mean, the board have got to deal fairly with the information before it, and fairly with the offender before it. And in this case, as the facts indicate, the complainant herself may have failed to attend, but they had the statement. But they were able to evaluate that hearsay evidence, having heard from 2 live witnesses.
Yes.
So, I mean...
It's not on point, if that's what my lady means, in the sense that it's a different scenario very much from what happened in the appellant's case.
I don't think there's any issue between the appellant and the respondent that the parole board have got to deal fairly with the offender, and that means dealing fairly with the information before it.
Yes, the dispute is whether fairness requires you to make findings of fact before you act on an allegation. So to that extent, that's what Brooks is an example of. It's gone to the extreme. It's got all the information, all the material. It's even tried to have the complainant at court. So it's going through as close to a trial process as it could, and then it's frustrated at the end because of the non-attendance, but no one asked for the summons. What we have in the appellant's case is the reverse. We no longer obtain the hearsay, the first material. We no longer attempt to have a trial of that material in that sense. It's put to the individual. He's uncomfortable with it according to the board's assessment of that. And then you adopt concerns about the material you couldn't make findings of fact about. They make finding of fact as to one matter, and then the remainder they say we have concerns about. But without going through the process that Brooks has, which is, do you find these facts proven?
But Brooks is not saying that you've got to go through this process every time. That's the point.
It's saying in my submission is, it doesn't say you have to have a live witness and cross-examination every time. You can fairly deal with hearsay in the context. But it's not saying you don't do the fact-finding exercise. That's the key for my purposes. That it's the fact-finding exercise that follows from that hearsay.
Right,
So in paragraph 30, do you disagree with anything in paragraph 38 as a summary of the approach?
And then within 38, of course, there's a requirement that the claimant be given a proper opportunity to respond to the material. So part of the fairness.
Yes. I was just asking whether you disagree with anything in 38 as the approach.
No, my lord. It would be wrong to read it as talking as if it elides the fact-finding and the risk assessment process. So I don't read it as suggesting that one deals with risk assessment on anything other than the facts. And if one puts it in the context of the judgment that's being considered, and the fact that there had been findings of fact made, that in my suspicion is not a controversial point, as it were. And this case is consistent, if I may next go to Delaney, please.
And sorry, just to be clear, I probably should have asked you to read 39 as well, actually, just together with 38.
Yes, again, I don't read that as in any way undermining the fact that there were fact-finding exercised through the use of hearsay that had been fairly dealt with in the circumstances of that case. It had been right not to require the witness, in order to make findings of fact, you could do so anyway.
So this is all about procedural fairness, Brooks?
Yes, I know.
Yeah.
Yes. Procedures in relation to the fact-finding, which is the connections.
Yeah.
Delaney, please, if I may, is tab 19. This was a case where the decision was quashed because no factual finding had been made regarding an allegation, so as to provide the factual basis for the consideration. As my lord and my lady have already raised that case with me, you know that essentially I argue that it is correctly decided and to be followed. The facts one can take from 3 and 6, but perhaps one just goes to the principles at 10 and 12 and 13 in particular.
Yes, an allegation of violence cannot in itself found the conclusion.
Yes. One might have collateral facts that are found, exactly as we've discussed, but the fact of having had the allegation doesn't take you anywhere in terms of knowledge about the behaviour. Yeah. And in particular, perhaps to draw attention to, within 12, my lords and my lady will have picked up already on this. That
It's about 4 lines down. He's correct to submit.
Indeed. Yeah. And in the requirement to make at least some findings of fact as to what did happen, there is then a gloss added to that in my submission in relation in Morris, but the dicta itself, it is clear that it's requiring factual conclusion, a factual basis rather, for the conclusions on risk that are to be taken from it. So I just highlight that's where we'll come to its consideration in Morris, being given a slightly different, well, my suspicion, a materially different interpretation. This principle as well is well founded. If one goes back to Lord Justice Stanley Burnton in Broadbent at tab 10, still as Mr. Justice Stanley Burnton at the time, and he considered this point where there had been a charge, and also considers the point about collateral facts that were capable of informing the board. And so in particular in this judgment, paragraphs 26 and 29, for a fuller understanding, perhaps 25 to 27.
Yeah, we need to notice 25 as well. Well, the question he's deciding is whether the parole board's entitled to proceed on the basis of the charge alone, without regard to any of the evidence.
Indeed, indeed. And so once you have some of the material, we then go forward to 28, 29. We've got certain things that weren't in dispute. So I think this case was concerned with being in a van and not having an explanation for that, and the recall being based on having possession of cannabis in the van, etc. So there were various things that may not have amounted to the offence, and he'd explained he was doing casual work, etc. But there were facts about his association with this, what had been going on, that were known, from which one could draw a conclusion as to the risks of him being involved in criminal behaviour were he to be released, or re-released rather.
Yeah.
So the principle at 26 and the consideration of Brooks at 29, but in my submission they are consistent with the other authorities, and this is often cited as one of the statements of principle.
Paragraph 27 is against some part of your skeleton argument. When you suggest that the parole board has got to have all of the documents that would otherwise form the basis of
My lady,
the
I would
allegation.
accept.
Perhaps you'll row back from that a little.
Well, I would accept the proposition that it depends what you're trying to do. So if you decide that we can make findings of a certain nature based on this material fairly, then that's sufficient. So I think that without elaborating the point, it's that there should be a disclosure process that's as equivalent to the fair processes you have of a trial process as you can manage in the context, and as the fairness requires. But if, for example, you just need to know, well, was he in a certain location, then
Well,
that...
what we have in paragraph 28, which is a very good summary of what the board could properly find without finding that he'd committed an offence.
Indeed.
Yeah.
So it could be focused on, we're not interested in deciding whether or not this full allegation, these full set of facts were found. We would have enough with building blocks 1, 2 and 3. Let's have a look at the evidence we need and fairly that will allow us to decide 1 to 3.
Yeah.
Yeah. There are 2 other cases on this issue to look at, please. The Hull Prison Visitors ex parte Saint Germain case at tab 5. Concluded in that context that if a fact could not be proven fairly by the hearsay evidence, it had to be dismissed from consideration. So we find Lord Chief Justice speaking about that on page 1409.
Where are you reading from?
If I can go please to 1409, behind tab 5 of the authorities. Whilst it was possible to admit hearsay evidence, it was subject to the obligation to provide the accuser with a fair hearing, just below letter D. And then it, consistent with Brooks in my submission, sets out the approach to be taken to requirements with hearsay and witness requirements in particular. And then from the bottom of the page, we have the appreciation that in the instant cases, hearsay evidence was only resorted to supplement first hand, that's the usual, where a prisoner desires to dispute the hearsay evidence over the page, and for this purpose, there's a question in the witness, and where there are insuperable or very grave difficulties in arranging for his attendance, the board should refuse to admit that evidence, or if it has already come to their notice, should expressly dismiss it from their consideration. So that's if you cannot decide that you can fairly decide it on the evidence. So if it's the reverse of Brooks, where you've decided actually we cannot have that decision taken on hearsay alone, then the appropriate outcome is that you dismiss it or disregard it, because that's the fair thing to do.
Again, fact specific.
Absolutely, but as a principle, what you have is if the facts are you can fairly carry on the hearsay, Brooks, carry on the hearsay. If the facts are you can't, Saint Germain, well then you must disregard it because you haven't been able to prove that on a fair basis. So then,
sorry. I don't think it's that you haven't been able to prove that on the fair basis, which is the way you finished that sentence. The reason you disregard it is it would be procedurally unfair to allow the parole board to consider the information. It's got nothing to do with whether you establish facts.
Yeah, my lord's absolutely right. That is a more accurate way of putting my unfortunate shorthand at the end of the sentence. Yes, that is the point, that you have decided you cannot proceed with that on a basis of fairness. You then discount it.
Yeah, but it's distinguishing between procedural fairness and the question of whether you make a finding of fact. You could still go on and make the finding of fact, you just can't do it with that particular piece of evidence.
Yes.
Yeah.
The case of Coyle in the Northern Irish High Court, which is our tab number 17, quashes the decision of the parole board equivalent commissioners in Northern Ireland on the grounds that they have failed to properly consider the nature of the hearsay that is controversial and therefore the shortcomings or limitations to it. The same rule applied as Rule 23. At paragraph 13, we can see the version of the rule that's in place to the same effect as our rules in this jurisdiction. And the case, of course, as one would expect in Northern Ireland, considered the cases of Sim and Brooks and others in this jurisdiction. The conclusions are set out at 22 to 24, really. So it's somewhat of perhaps an in-between situation where one has the hearsay which is potentially cogent and you are acting upon it, but you have to then do so in the manner that takes into account the considerations that must be in place to fairly be making assessments and to come to reasoned conclusions about that material from the witness statements and the apparently cogent hearsay evidence in that case. Moving on to a different subheading, as it were, in terms of the case law, I mentioned earlier the distinction between facts found and the separate evaluation of risk in the John case, and I don't know if the court has seen that in its pre-reading or not, as it's only, I'm afraid it's not in the skeleton arguments, but could I invite your attention to it nonetheless? It's our tab 23, and it's a relatively recent case, although it does highlight some earlier decisions. So in a nutshell, this is a situation where the parole board makes its recommendation about movement to open conditions. The Secretary of State is entitled to consider that and to disagree or agree, but when he does so, he has to distinguish between disagreement on findings of fact, which he's not permitted to do, and disagreement on evaluations of risk and other matters, which he is entitled to depart from if he can give good reasons to why he's formed a different view. So with that context, as it were, to what is going on, if I ask the court please to turn to paragraph 40.
40.
40, please, so page 9 of the report. Yeah. In citing the Divisional Court's decision in Hindavi, you'll see indented there a discussion about the parole board, which was expert in the assessment of risk and immunised from external pressures. Panels carrying out the work operate in a manner much like a court, sifting and analysing the evidence when there is an oral hearing, making relevant findings on disputed issues, which could not be resolved by review of the papers. So they're making findings here, and then Lord Justice Thomas, as he was, moves on at 58 in the indented text to talk about the clear distinction between findings of fact and its assessment of the risk. That's applied in this case in the analysis that Mrs. Justice Heather Williams provides, at paragraph 47 in particular. And towards the end of that paragraph, you see the reference that I've made earlier to past events as opposed to prediction of future.
Right, in 47.
Yes, sorry, right at the end, my lord.
Oh yes. Yeah.
So the appellant's submission is that this is consistent with our case as advanced, that there is this two-stage process, as it were, and two distinct elements to a parole board determination. One other issue that, of course, arises in relation to the grounds, other than how to take into account material, is also when it is that it's appropriate to engage in the process of looking at unproven allegations. And so, with something to say on many of the issues, we have the DSD case, which, if I can just draw the court's attention to, you have.
So, are you getting into your exceptionality argument now?
Well, my lady, I'm not planning to elaborate on that too much, but I probably can do it at this point, dealing with that case, because it all does stem from that case. Either that is a case that suggests that it should be happening all the time, or it's a case that suggests exceptionality, or whatever the court will draw between those two.
Well, that's one of your arguments.
Indeed.
Where do you stand on that now?
The submission I make is that War Boys is and was an exceptional case, and the intention was that the board should look at non-conviction material if it was going to materially inform them in their risk assessment in a different way to the convictions. So it's when the conviction record is insufficient and where you have, therefore, a need to look at it and you have reasonable material available to do so. So what DSD looks at is a case in which, because of its exceptional circumstances, there is a volume of material that's been simply ignored, a submission made to the court. The board always has to ignore all the material, no matter how good it is, because we're not here to determine criminal liability. And the court saying, no, that's not right. It is material considerations. You've ignored all these different pieces of information. And had you looked at it, you'd have understood his risks very differently, because you have very limited convictions compared to very extensive offences.
The problem you've got there, Mr. Rule, is how can you know that the antecedent record gives a true reflection of future risk if you don't look at unsubstantiated allegations so far as you're able to? Because only then will you know whether or not it is in itself sufficient.
Yes. My lady, I accept that one has to draw the line in a way that reflects the needs to look at, the appropriate legitimate needs to look at non-conviction matters. So I don't accept the parole board's concern raised in argument that if you don't look at it in every case, you're going to exclude relevant material that informs public protection. The point is, what is it that's relevant that informs public protection? So all that we say is that the line that is suggested in DSD is not one that suggests this is an exercise that always has to be undertaken, that you go back 20 years from before someone was imprisoned for the index offending and before outside of their established record in order to look at things. So the question will be, on a factual basis, if the board was presented with an allegation of facts that may or may not have occurred in the past that could not alter its current understanding of the risk, then you don't need to go into this. You don't need to have the avoidance of a criminal process, the avoidance of all the safeguards and the requirements of that, to go through a quasi-trial in the parole board to establish something that no one else has tried to establish.
Well, doesn't the guidance say that by saying it could be irrelevant?
No, well, it's drawn irrelevance at a particular level. What it is not acknowledged is that you should decide whether it's going to add, not because it's simply something similar or something, it's going to add to your assessment of the risks in a material way. So when one looks at the guidance, I accept that it has a irrelevance category, as it were, but one has to understand what's relevant in terms of adding to the picture, because it'd be relevant if someone's committed an offence or committed behaviour that gives rise to concerns. It will always be relevant. But can it be relevant to the parole board's purpose if you already have those risks known to you? Because we're not talking about current offending, we're talking about historic offending. The parole board, to establish the future risk, wants to understand the past, but also makes its evaluation, its actual decision about the future risk.
Yes, but how can they know that they've got the whole picture without having regard to the information put before it. Once they've looked at the information, they could say, well, this relates to a time when he was 5 years old, and we're now dealing with a 64-year-old who's gone through 3 sex offender treatment programs and all the rest of it. So they can then say, well, this is irrelevant. We don't need to trouble you with this. And you could be getting to the McKendrick scale of things. But how can they know what's relevant without knowing what's in the information?
Yes, I'm not setting the threshold at an unreasonably high level as to know at the start what you'll know at the end. There'd be nothing wrong with saying what you're suggesting to us could give us new material that helps us to ascertain it. So if I put it into a bit of context, what you had in this case with the psychologist assessing, I've looked at all the allegations as well as his previous convictions. My risk factors aren't affected by the allegations, so they don't affect whether I think he's had the right treatment. And the offender manager and the offender supervisor both saying the same thing. So they're looking at the individual they're assessing from all the work in the last 10 years and saying, well, actually, if there were those offences in 20 years ago, they wouldn't change our current risk assessment. Now, the parole board could disagree if it was saying, actually, we think there's a risk factor that what we're being told, because it'd have to be raised with them, what is it that is this allegation? Well, actually, if that were found, if we find that's what happened, that will affect us because that will give us something different to what we already have. So you could have an example where the board agreed with the psychologist and the 2 officers and say, well, actually, yes, we agree. There's no point in trying 2 historic rapes when we already have 8 rapes of a similar nature that are his conviction record, because there's no advantage to us in the risk assessment from knowing. Let's say there wasn't any sort of different pattern of time or something like that. War Boys is an example of that sort of thing.
But that's not exceptionality, is it? It's relevance.
It is, but how often is it relevant? So in my submission, if one properly understands relevance, then we won't have trials of unproven allegations all the time just because there happens to exist an unproven allegation. It should be focused on where it's necessary to do that, because it always endangers fairness that we're going back 20 years to something which wasn't dealt with at the time. So there could be good reason to do that, but if there isn't good reason to do that, then we don't do it as a matter of course.
So in practical terms, an allegation is made, and let's say it's got an evidential basis for it. So what you're saying is the parole board should look at the allegation and the evidence supporting it, say, well, if this is true, it may affect our decision. If it's, and therefore we ought to investigate it, make such findings as we can. Or they may say, well, looking at this allegation and the evidence in support of it, it doesn't add to the sum of human knowledge as far as we're concerned. We needn't investigate it any further.
Yes, exactly. Yes, and to some extent, whether it's defined as relevance or exceptionality, it's about where you understand the purpose of looking at unproven allegations and when that's going to be necessary, rather than that because we've been presented with an allegation, we now have to look into it, which would be an unnecessary approach, but also potentially unfair because we're looking at things for no particular reason outside of the context where they should have been.
Look into it is rather. The parole board has a statutory duty to consider the information. The information in your example is an allegation plus the evidential support from it. So the parole board, in order to comply with its statutory duty, must consider that. But what you're saying is, on consideration, the parole board may conclude that it is not, that they don't need to go any further,
Yes.
because even if proved on the balance of probabilities, it would not affect the risk assessment.
Yes, unless you were in a McGettrick exceptional case, you say that is just something that is prejudicial, which has to be removed for us to carry on fairly. But leaving that exception aside, yes, you are obliged to consider it, but not then to regard it as relevant and to take it into account in your consideration.
But you've already considered it in terms, haven't you?
Yes.
You have taken it into consideration to disregard it.
Yes.
So you've
Not
fulfilled
into
your
your
duty.
determination.
Yes.
Well, DSD obviously is a starting point not only to the timing point but also to consideration and draws comparison with the criminal courts, as Muller will have noted. Could I just say in relation to the exceptionality point, for the court's record, I've referenced that in my skeleton argument at paragraph 33, but I set out 9 particular features of the judgment, of the facts rather, in War Boys in the grounds, paragraph 44, which you find on page 251 to 252 of the claim bundle.
Could you give me that number again, Mr. Hall? 241, did you say?
My note has 251, my lady.
251, sorry.
Yes, so it's, yes, please, 251 of the core bundle.
Yeah. Paragraph 44.
Please, yes.
Just by way of warning, Mr. Rule, I think you're going to have to conclude your submissions by 1 o'clock at the latest.
When I turn to the submissions, I won't be returning to the cases. I'll be relying upon them. So this is time well spent, I hope. So in relation to that case, you have the context in which the decision is taken, and then if I invite attention, please, to DSD itself. Briefly, we have that at tab 18. And the result will be well known to the court, but it was a quashing of the decision for having failed to take into account relevant considerations in not looking at previous matters. And the court dealt with the arguments of the parties, from really page 330 of the report onwards. It makes reference to, of course, the need to consider fairly and the use of evidence as well as information, and in particular deals with the section 239 point at paragraph 151. But that's not a distinction from the criminal court in Considine, paragraph 151. The court will note, please, that the submissions have referenced a number of criminal cases starting at 147 with the case of Kidd and then the case of Ferrar at 148. Considine is then considered at 149. So as well as at 151, that's a reference to what's been considered at 149 above. And you have Considine there at 37 in particular. So the court has drawn its comparison to the way in which the dangerousness risk assessment is conducted by criminal courts on the basis of fairly using information outside of the criminal conviction itself, and the way it goes about that. Of course, that is not as a matter of course. It's where it's going to change the court's approach to the risk assessment rather than simply add to what could have been on an indictment or subjected to charges. And then his lordship deals with 152 reference to Sim and Brooks and also McGettrick.
Yeah.
Where it deals with the divisional court's judgment in McGettrick at 153, that's the indented paragraphs, including 33. The issue at 30 is reversed by the Court of Appeal. So you can see that referenced at 154. I won't take the court to it now, but we have in the bundle that Court of Appeal decision of McGettrick it's paragraph 35 thereof, which will be relevant.
Yeah. Yes, 155 is really the conclusion on this question.
Yes, 154 and 155.
Yeah.
So at the end of 154, we have the constraint that the board must act fairly, and then 155.
Yes.
159, you have reference to being driven to conclude that on the particular circumstance of the case, the board ought to have carried out that further inquiry, and then lists some of the very special circumstances to which my paragraph has followed a few others.
Yeah.
And this would have had a materiality. So if you go then to 161, having looked at the quality of the material at 160, you had obviously the judgment of Mr. Justice Green by then as to the civil claims and fact-finding. In our judgment, this material, 161, would have provided a sound platform. And the evidence should plainly have been obtained, 162. So
Yes.
it is a process in my submission which is equivalent to that which one would normally expect to see, where there's some gathering of the information available, such as it is, which might include hearsay, and then trying to use that material to inform a risk assessment, which is going to be informed by the particularly important nature of that material. So in Warboy's case, that was important, as the court explains, to understanding really what he'd been doing, rather than the conviction record being woefully inadequate for what should have been.
So this was a case which, going back to your previous point, is one where the parole board should have said there is information which prima facie looks to be relevant to the assessment of risk.
Yes.
So it works both ways.
Indeed. So there was enough known publicly, as it were, or for the Secretary of State's officers to have given them.
Well, there was enough in the dossier, plus 80 plus potential victims.
Yes, but nothing more in the dossier. So that was, they were on notice, as it were, that there's this avenue that really you need to know about. As I say, McGettrick, Considine you have in the bundle, but you've seen the references to that and to Farrar in this judgment, so I won't ask you to go to those. McGettrick, if you wish to see it, it's tab 14, paragraph 35 and 36, but again, you can see the outcome there, and that's the point that I draw from it, that it recognises that fairness can sometimes need the dossier to be filleted of material. So if I may turn to Morris, which I need to deal with, please. That's our tab 20. On its facts, as the court, I know, has read this case already, I'll attempt to be brief. It concerned one incident where there was reliance on the fact of the arrest, as well as other matters, and it's the fact of the arrest I've drawn attention to that I would take issue with seeking to place reliance on, whereas there could be relevant material from an altercation that's occurred, etc. The harassment warning letter does not, to take issue with my learned friend's skeleton, mean that the police reasonably suspected there'd been harassment, as opposed to that they were warning the individual who had tried to contact on what must be at least 2 occasions reported to them as having been at least 2 phone calls, tried to contact his ex-partner, and she didn't want him to any longer. It doesn't require any fact-finding or require any suspicion on the police part. They simply have an offender in custody who has access to a phone, and she says she doesn't want him to phone. They could issue a letter without anything more. It regards the letter as proof of you having been given this letter. Should there be anything in the future, we'll rely on this. So it's that sort of material. So it doesn't provide the basis for the respondent's interpretation of that.
Well, it is a building block, to be fair, because if he'd had the letter and he was then involved in a violent altercation, it shows that he had disregarded the letter.
Yes.
So it is relevant in that respect.
If it had been that way round, but it was 2014 for the allegation of there being an argument or unsolved, and then there was 2017 this letter given from the partner. The partner had been told about his previous convictions, had ceased contact, and had presumably had a phone call or more, and had gone to the police, and then they'd given the letter, but nothing else. There was nothing after the letter, and it was a different lady. Yeah. But it is more, I think, just a point about how it was put in the respondent's argument that I ought to do it. But the question as to when it should be relevant to engage in the process of going down these avenues was looked at in Morris, and you'll appreciate from my submissions about DSD that it's too wide to suggest that in every case where it's presented to the board, they ought to be looking at this material. And
sorry, just say that again.
That in each case where the board is presented with an allegation, that it ought to look into it. It's not as straightforward.
Look into it, right? I thought originally you said look at it, but you accept that they do have to look at it. Whether they need to go any further is a different question.
Yes, whether they are obliged to do anything with it, having considered it, having looked at it. The reference in that is to paragraph 49, but it again will beg the question as to where the line of relevance is drawn, I think.
Well, you don't make that contention anymore. You don't say they should ignore it. They say they should consider it, but may decide that it's not relevant. It would not be relevant even if proven.
Yes, and therefore not to take it further. Yes. So there are 5 criticisms that I make of Morris with respect, and the last of which is concerned with its precedential value and not being consistent in my submission with Brooks and Sim that we've seen. But so far as the decision is concerned in its text, if I start with the first point at paragraphs 55 and 57, in my submission, the court is wrong.
Sorry, you left paragraph 49 behind.
Yes, my lord, I was perhaps going to skip around a little bit on topics rather than necessarily go through it. Like I could possibly.
I mean, the last bit of 49, I think it encapsulates the exchange you just had with my Lord Justice Lewison, doesn't it? It's where allegations may be relevant to decision making, they should be considered. What it doesn't go on to say is, but they may then, as it were, not be pursued once it's appreciated that even if true, they wouldn't add to the general sum of human knowledge. That's the way you would have the last part of 49 interpreted.
Yes. Yeah. And so in terms of the point that the court suggests that the panel is entitled to act on an allegation in the absence of facts in relation to it, that's really paragraphs 55 and 57. And for the reasons that I've already given, our submission is that it's not right that the parole board proceeds on any non-facts.
Yes, I mean, the bit you disagree with is the gloss on what was said in Delaney.
Yes, yes. In 55, yes. So the end of 55, the though for sake of clarity onwards.
But if one understands allegation as meaning the conclusion drawn from a number of different building blocks, you would accept that some of the building blocks may be found as facts, even though you can't go all the way to the overall allegation.
And at 57, at the end of that paragraph, it's phrased, so long as there was a sufficient factual basis, however limited, on which to take the allegations into account, the board was not acting unfairly. This is again to do with the term allegations being held separately from facts that you have, that you're then drawing conclusions from. which would be the simple approach that we submit is right.
And you're also saying that if that suggests that anything less than the balance of probabilities is sufficient, it's wrong.
This is my second point, my lady. So I go to paragraph 53, which deals specifically with that point as well. So there, my lords and my lady will see, for example, the board might find there's a significant chance, short of a probability, that a given allegation was true.
Yes, I've got to confess I find difficulty with that proposition. And I'm agreeing with you, in other words.
Yes, my lady, I envisaged that was the difficulty you...
Well, particularly given that the guidance says that you find facts on the balance of probabilities.
Yes, and there's... I don't envisage anybody's arguing that Brooks and other cases are wrong about finding facts on balanced probabilities, i.e. that's a fact-finding standard that applies to the board exercising its functions. I certainly haven't advanced in this case that it should be the criminal standard, which is a matter dealt with in the past. So,
but again, part of the problem stems from what you mean by an allegation.
yes, and if you remove that and just talk about facts, then we have the facts must be demonstrated on balanced probability, and then you use all that information, all those facts you have, to then conduct your risk assessment. And so, in essence, we submit incorrect at paragraph 53 to draw this novel standard of proof that isn't otherwise recognised in terms of facts.
But you would agree that if it was directed towards an assessment of risk, that we don't have any
Absolutely.
problem at all.
Absolutely, yes. That's simply an evaluative matter for the board. It doesn't bear a burden. Yes.
No.
So past fact, balance of probabilities, future risk, significant chance.
It's the as section 28 as discussed in the authorities. So no longer necessary to confine as to whether it's necessary to confine for public protection, for the safety of the public, and then look at the authorities that slightly deal with how one deals with that. And I think my learned friends have referenced the Watson case, which is in the bundle. There's also Supreme Court cases that looked at that, Sternum being one example and others. So, but yes, applying that, you're not under a burden of proof. You're applying a particular test and your evaluation to that.
Right.
So those complaints made about paragraphs 53, 55 and 57, the fourth point about that is in essence dealing with how this...
Where's number 3? I've only got 2 so far. Dealt with 55 and 57 as number 1. 53 at number 2. What's number 3?
Number 3 seems to me to be a subdivision of 2. But let me put it, as I've written it, let me put it in this way. The first point 2, as it were, is that you are conducting it. You are completing your exercise without establishing the facts at all. And 3, I have subdivided the standard of proof that's being applied here, to which you are operating. The 2 points may actually be 1. I apologise if that appears to be the case. But the fourth point is that there is this elision in my submission in the dicta in Morris between what is the fact-finding part and what is the risk assessment part. And that can be compared to the cases we've looked at of John and Delaney, for example, which more clearly recognise that difference of approach. And that, for this point, you've seen paragraph 55 already, but it arises really in relation to that complaint as well.
Yes.
And I don't go back, of course, to any of those authorities, but if you just note for a moment at 51, related to that point perhaps of elision, at 51 in the lower paragraph on the page, we'll see reference to Brooks and the burden of proof has no real part to play. That's absolutely right so far as it was referenced in Brooks to do with evaluation of risk, but it's not right as far as it was in Brooks or ever elsewhere so far as fact-finding. So that's in my submission, incorrect when one appreciates that distinction in the Brooks case and others. And so you have, of course, Broadbent and Coyle as other cases that aren't, I think, referenced in that judgment, which I placed reliance on. with that discussion of Morris, could I please go to the decision in Pearce itself?
Yeah. Well, the judge followed Morris.
He did, and he acknowledged he was bound to do so.
Yeah. So if Morris is wrong, it's likely the judge is wrong.
That is the appellant's submission, yes. We would recognise, to give correct acknowledgement where it's due, that in some of the discussion of the legal principles, his lordship below actually seemed to agree with the submission that I advance on behalf of the appellant. So to an extent, we find some of the dicta in the judgment on principle that appears to support or to confirm that which I advance. However, in the application of that to, firstly, the guidance on which he was in any event bound by the divisional court, and in consideration of the facts of the case itself, in my submission, it's not entirely, it's not correct that those principles were rightly applied to those decisions eventually in this judgment. So,
yes, I mean at 34, for example, he says finding facts logically comes before assessing risks, and then at 39 he says the board will find such facts as it can, and then consider the logical effects of those facts on its risk assessment.
Yes.
Well, that's your case, isn't it?
Absolutely. So it's a surprise that I'm arguing against it, but
But
so
it could just be that he read Morris far more sympathetically than you're asking us to.
it seems that is one possible route to to the outcome in the case. It's also potentially possible that although having accepted those principles, the allegations issue and the facts versus allegations rubric factors in somewhat, because there are a couple of points which I would submit are not entirely consistent with those principles that his lordship has identified. So if I start on the page that my lord's identified for me at 118, we've got the paragraph 34 that was mentioned and paragraph 39 beginning. Although one then has the continuation of that paragraph. So at paragraph 39, it then continued, if the board can only conclude that there might have been an assault, that conclusion may be of little assistance to it. Logically, it has already followed that that is of no assistance as far as the assault is concerned, because you haven't found that there was an assault. I appreciate that means an action of whatever is the nature of the assault, but that in itself is confusing assault with facts. So we're getting into the problem area that we're not talking about. If they found facts of a certain nature, they may be of assistance. So that in itself is somewhat ambiguous, at least, perhaps.
Can you give me the reference to the paragraph again?
So this is paragraph 39 on page 118.
Oh, I thought we were in the judgment of the...
Sorry, I've yes, Mr. Justice Bourne. So claim bundle, page 118.
Well, assault would involve either some kind of touching or putting somebody in fear. So there might have been an assault, but there was an altercation. Those two are not inconsistent.
Well, I have no difficulty with if satisfied there was an altercation. It doesn't matter really whether the police were called or not. But if there was an altercation, you found a fact of behaviour that is relevant to the risk.
So there was an altercation. We can't say it amounted to an assault.
Yes. So I don't have difficulty with the idea that you have a building block, an altercation, or a fact, an altercation. But the fact that you could only conclude there might have been an assault, that conclusion may be of little assistance. It wouldn't be of any assistance because you haven't concluded that there was an assault, probably an assault.
Well,
So,
but isn't the judge saying, well, the overall allegation is assault? And that's not of any great help. But the building block, one of the building blocks, is the altercation. And you can find that.
yes, my issue is only that if you can't find that there's been an assault, then you're not working on that basis. You leave that to one side, find what you've got. You've got an altercation, you move on that. So when he says of little assistance, in my submission, that was slightly watering down the principles we've just seen that he appeared to agree with. So That's the difficulty I have with that particular sentence. That
So
it
it's
doesn't,
just that
yeah,
sentence.
just that
the,
sentence.
The final sentence you agree with?
Yes.
Because it's one of my Lord's building blocks.
Yes. Yes.
So you'd replace the word might with should be of no.
Yes.
So maybe you replace the word maybe of little to should be of no.
Yes.
Yeah.
And if one goes back to His Lordship's discussion of Morris, if one goes back to the consideration of the guidance firstly, paragraph 14 on page 112, in the passage that is not indented, in the judgment itself, having summarised that the guidance states that allegations should be disregarded only where not relevant. If they're relevant, the board should go on to consider whether it can make a finding of fact. If the board cannot make a finding of fact, it is nevertheless encouraged to consider the level of concern raised by the allegation. So that's a recognition of what my submission is. That's the third way in the guidance. That's the problem area of the guidance. And then considering Morris, His Lordship's referenced paragraph 55 and Delaney, that's paragraph 24 of this judgment, page 116.
No.
And at 25, he's describing, in his own words, the lack of a strong factual basis for the allegations and the lack of reports and statements only affected the weight which the board was entitled to place on the allegations, not the question of whether it can have regard to them at all.
Yeah.
Again, that's in this discussion of allegations and lack of proof of facts that creates the issues. And then, of course, 63, which he has referred to.
But as an account of what Morris decides, it's correct, isn't it?
So far as 25 is entirely a description of Morris, yes. If he's adopting that,
Well, he has to.
Well, I appreciate that. That's the slight unreality to the proposition. But yes, so far as he's bound by that, he's then following a course which, in my submission, was wrongly set for him. And 63, of course, is the reference to the guidance, the reading given to it in Morris, which is again binding upon him insofar as finding that the guidance could be read such that it was permissible to have the ability to consider allegations when not possible to prove the allegation on balanced probabilities. And we return to the issues in Morris and the guidance itself, which we'll come to in a second. So His Lordship's just, my Lord and my Lady will have seen this already, but his conclusions on the guidance are set out on page 124, really.
Yes.
Although he accepted at 60 that the guidance could be clearer. And I reference those two paragraphs in particular because when we turn to the revisions to the Parole Board's guidance, which the Court might be interested to consider, this appears to be the basis, 59 and 60, for two of those insertions to the guidance. Before I leave the decision below, if one goes forward to his conclusions on ground one, over to page 126, please. At 72, he refers to if the evidence relating to one or more of the allegations were particularly flimsy or unsatisfactory, a submission might be made, it would be irrational to give any weight to such allegations. But that wasn't a rationality challenge, and he placed reliance on that. At 71, it must have regard to the information, has to be read, of course, subject to McGettrick in my submission and the requirements of fairness there. In terms of his conclusions, I'll be extremely brief if I may. At 74, paragraph Roman numeral 6 rather, the 5 allegations were of concern and were relevant to the question of risk. This is relevant to the Parole Board's decision, of course, that it, acting on the guidance, doesn't have to find facts about the other 5 allegations. It can simply say they're of concern. And so it's an application, in this case, of the guidance, which follows from the point as to whether that guidance is correct or not. And then his lordship tried to distinguish at 76 Delaney from the case in point. At 78, he explained that rather than expressing concern, the panel should have explained what facts they found and precisely what concerns arise from them. But he regarded the finding of facts as or at least setting out the facts that you found something of good practice at paragraph 79 at the end of that.
The judge was distinguishing in his paragraphs 76, 77 and 78 between the allegations.
Yes,
So
each allegation.
Bourne J said, so far as 1, 2 and 5 is concerned, this appeared to him to be appropriate for the board to have concluded on the basis of the material before it. And you wouldn't disagree with that, I don't think.
There is an overall issue as to the way in which the board set about all of that without the material, because it may have obtained material that would have revealed different information that may have led it to a different fact. But
you're not suggesting, are you, that the parole board have got to say, well, we've got evidence of DNA that matches Pearce in a 12-year-old's knickers. I'm sorry to be blunt. And whether or not she consented, it is suggestive of sexual activity, which would be an offence under law.
Absolutely.
So you're not suggesting that they've got to say, but of course it could be that this is secondary transmission and it could be somebody else's. I mean, that would be beyond the pale, surely.
What I'm not submitting is that it would be impossible for them to have made a finding of fact based on what information they did have, but that the fair process, I would still say, would have been established why it was that wasn't charged, because it seems a case.
Well, I've got to say, Mr. Rolfe, that if you did that for every case that isn't charged, there'd be an awful lot of investigations going on. Prosecution decisions are very hard to fathom sometimes.
I accept that, but it would be much more satisfactory if there were more information known about what that material was, and therefore.
But aren't you trying to have your cake and eat it? I mean, the fact that the CPS advises against prosecution could be on a public interest basis.
Exactly. Yes, it could.
And therefore, you're saying, well, unless the CPS charging decision is before the parole board, then they can't go on to make any findings at all. I mean, that's a bit ridiculous.
Well, no, my lady, what I submit is that if you were to look into the matter, you might find that the CPS decision or police decision was taken on an evidential basis, which set out for you why that decision was taken. That might be relevant. But I'm not saying that it's not a sort of cast iron that must be there, it must not be there, but it's just a question of whether fairness is being done by how you're going about it. So it appears to be material which you could act
on the balance
but the
of
question is
exactly. Yes.
But is it being fairly done without knowing more about it? That might be open to question on a given case. It shouldn't, I think, be assumed that you don't.
Well, we're looking at this case now.
Yes.
There was evidence before the parole board that DNA had been found in the underclothes of a 12-year-old girl who denied a sexual relationship with the offender, but which was quite frankly suggestive that something of a sexual nature had occurred, whether it was consensual or not. And she could not consent.
Yes, and I accept one doesn't have the criminal standard of proof to apply to the allegation. I'm only positing the point. There are cases, and my lady's already mentioned, there are secondary transfer issues. This wouldn't appear on the face of it. But when I was talking about principle, I just want to be careful that because of the number of cases that will be affected by whatever principle the court adopts for guidance, as it were.
Yes, of course, but I thought you were talking about the instant decision now. That's why you've taken us to the judgment, isn't
yes,
it? And
yes,
these particular findings that the parole board made and that Bourne J considered with some care.
Yes, but it's not the fact findings that that's a fact finding here. My lady had posed a question to me that I tried to answer, but my target in these proceedings is not on facts that were found, but on the non-fact finding, which is the 5 allegations of concern. So that's the submissions for the purposes of today as to what the principles of principal approach are, rather than the application.
Well, what did Bourne J get wrong? Because in paragraph 78, he says the reasoning could have been clearer on the 6th overarching conclusion. Rather than expressing concern in general terms, panels should explain what facts they have found and precisely what concerns arise from them. That's exactly your case.
It is. The problem with this is that the parole board doesn't raise facts that it finds 5 concerns from. It just says we've received allegations, we have concerns. So it's that. It's not that 78 is wrong as a matter of principle at all. It is exactly as my lady says. But it is whether in this case those 5 concerns, not the facts found, but the other ones, were sufficient to be done in the right way, in the right approach.
Yeah.
Is concerns a helpful word? I mean,
Not-
what in fact are they doing? Rather than expressing concern in general terms, panel should explain what facts they found. You say yes.
Yep.
And then precisely what... It's not concerns arise, it's
risks.
what risk...
Yes.
What
risks
risk
would be much
assessment is
easier.
based on it.
Absolutely.
So rather than use this word concerns, you're saying you would agree with the second sentence of 78, provided it's made clearer what elements of risk arise from the facts as found.
Yes. And I read that essentially as I think what his lordship meant. And I would certainly read concerns there in the second part, where it's not in speech marks, as risks, really. That's the legitimate concerns from the facts, is the risks that it tells you about, the information that...
The word comes from the guidance.
It does.
Yes.
It does. Concerns are raised over allegations. So we have these 2 concepts, as it were.
You're saying it's an unhelpful word if you actually want to break down the process that should be followed.
Yes. As an ordinary English word, I understand it's featuring in the way one would express a judgment, perhaps, a risk assessment. You would have your concerns about this point, about this thing, this risk. But it isn't necessary to include in the formulation of the approach, which is to establish the facts and then to establish the risks that they inform you of.
Unless otherwise it be taken that because the allegation is so serious, that is concerning.
Yes. Almost every allegation will be of concern automatically because of the nature of it. So it's then a matter of going through the legal process with it. So I leave that there. May I just draw attention? I'll be able to summarise the grounds, but if I can just draw attention to the guidance and deal with that with the court, please. The original guidance is set out in both guidance, in fact, are in the core bundle. Beginning at 275 with the original version. I have put to one side the Secretary of State's guidance. Can I, for the court's note, now I'm dealing with guidance, just put a footnote, as it were, or a side note to the Secretary of State's guidance. There is a copy of that in the supplemental bundle, pages 11 to 16,
Supplemental bundle.
pages 11 to 16.
Yeah.
And this was what followed the War Boys decision. The Secretary of State provided this guidance. And really one finds, you'll see the bold type on page 9, all relevant evidence should be included in the dossiers, possibly police evidence. And it expressed its opinion, no more than that, I accept, that it would be in somewhat exceptional cases necessary to do it. And that sometimes report writers, bearing in mind the evidence of the allegations, should come to two different forms of risk assessment.
Yes.
So that was the appreciation of DSD that was taken in, of War Boys that was taken in the Secretary of State's guidance. The Parole Board's guidance, which is challenged in the core bundle, and you have the three routes that it provides for. The first of which is uncontroversial, and the second of which is uncontroversial. The first of which being that one can disregard the allegations. So if I'm on page 276, going forward to 277, you have a paragraph 8 that deals with, under the title relevance, which is a word that features later in the guidance, but otherwise is not related to the specific ways in which it goes through. At paragraph 6 on 276, you have the three routes set out, A, B, or C, and it's an or as opposed to C following from A and B. You have the reference to allegations of relevance that may be of relevance to paragraph 8, and then you have findings of fact at 11, and again, it correctly reflects the law at B and C, that you must be finding facts in a fair manner. And it gives a word of caution at paragraph 12, that panels should exercise caution, as it may not be possible to have a fair hearing dealing with allegations. And then, of course, the source of the complaint, as it were, is when one then moves to the C, the or C, making an assessment of the level of concern, expressly by paragraph 18, when it's not in a position to make a finding of fact, because there's insufficient material to do so, or because it would not be fair to do so. But having then concluded that you cannot find the fact, you then go on to make an assessment of concerns arising from an allegation at paragraph 19 and paragraph 20. Now, if I may turn to the new guidance, just to give the court a flavour or perhaps assistance with what has changed. If one then goes to 284, you'll see that the A, B or C remains, and the relevance issues remain, including at C, potentially credibility undermined by information of alleged additional criminality. Of course, his credibility could be undermined by facts you found of previous credibility, of criminality, but not just the allegation of those. But that is an example of how relevance might be taken to something which hasn't been found as a fact. Then relevant allegations 9 or 3 make an assessment of it. So we still have the or in paragraph 6 and in paragraph 9, but these are different ways to deal with an allegation. There is a new addition to findings of fact, paragraph 15. The new addition, I don't think material, but panels should remember that the burden of proof is not on the prisoner as entered. If it assists the court as well to know that in the supplemental bundle, I think there is a track changes version of the guidance.
Well, the new guidance actually indicates what changes by document history 1.1, July 2021, paragraphs 15, 18, 20 and 24.
It does, and they're not very substantial. I can tell the court which ones are new as we go through this, so, but I just thought to let you know it's there. But this is more than sufficient, I think, for drawing the point. So at the bottom of 18, on page 286, The new part begins, however, in cases where there is a mere allegation. So you now, this is redundant, of course, of Morris. So this seems to be the source for this, is the dicta in Morris. Cases where there's a mere allegation without any factual basis that can be identified by the panel, or the allegation is not relevant to the question of risk before the panel, the allegation should be disregarded and no weight placed on it.
Well, it's more likely Delaney rather than Morris, isn't it? Because Morris actually gave a gloss to it that's not incorporated into this guidance.
It does, but I think it is Morris where it's the mere allegation point. I think that her ladyship had referred to mere allegation as one which hadn't met had some factual basis, even though it hadn't met the balanced probabilities for a fact to be found.
Okay.
And so that's what I've envisaged is where this comes from. But in any event, it's probably more important what is now in the guidance for the court to assess. At 20, we have an addition, which is within the addition after this will require an examination of the allegation and any underlying facts that the panel can find on the balanced probabilities. So the word "and," of course, suggests that you're still examining the allegation rather than, and there is ambiguity to this wording, but examining the facts you have found on the balanced probabilities. And if it had been meant to reverse, as it were, route C, so that the third way, in fact, was only the same as the second way, making the findings of fact and then what you do with it, it wouldn't go on to have the content that it remains to have, both in the disjunctive or that's been used earlier, but also in relation to the way in which it talks about giving weight to an allegation. If we've spoken about a fact that's been found, then that is the finding. That is what you're operating on. So there has been an action that amounts to something that's given you a risk information. But here we have A, dealing with the credibility of the source. But once you've decided it's a fact, it's not relevant, the credibility of the source. It's a question of what the fact tells you about risk and the weight you're giving to that risk, that fact in the risk assessment. Not whether you find the credibility of the source, which is still what's concerned in A. And B, allegations that are supported by other information normally have more weight than allegations from a single source. Again, these are relevant factors to evaluating hearsay or to evaluating evidence to come to your conclusions about the facts, but they're not relevant once you have those facts to what you're then assessing about, what they've told you about risk. And E, potentially, 20E may add to the confusion somewhat as well. In that it's either a question you've established that fact.
I mean, what you're really saying is that all the factors in paragraph 20 are really concerned with fact-finding.
Yes, not concerns.
And as a guide to how to find facts, there's nothing particularly wrong with them.
Absolutely. Absolutely. So if you're establishing the facts and establishing the weight to the evidence you're hearing that allows you to make those conclusions, that's fine. But what's happened is, unfortunately, it's been put into this differential route where you have a matter of concern arising from an allegation outside of that process that would normally have already conducted at stage 2. Then 22, 21 and 22, we still have weight being given to an allegation, levels of concern. And then 22, this exercise of judgment requires panel to draw on its skills and experience to form a view about the level of concern that should attach to the allegation rather than to the facts that you found or to other material. And at
So
23,
21 should read, having analysed the facts, their relevance and the weight to be attached to those facts, the panel should then reach a judgment about risk assessment.
yes, it could even be the impact this level of risk has on the parole review. So the word concern is probably best removed because it's liable to...
Well, it's my Lord Justice Snowden's point again,
Indeed,
isn't it?
indeed. If concern were understood as the mean risk, it wouldn't be objectionable, but it's far better to avoid the unnecessary redolence of, well, it's concerning. Of course, it's concerning to hear about this, but it's really about what you are doing with that legally. And 23, similarly, in my submission, the wording is not apposite, where it's an allegation that is relevant, the parole review and of significant weight is likely to be a matter of concern to the panel, therefore impact on its judgment regarding parole in one or more of the ways identified as relevant above. So that takes you back to paragraph 8, which was dealing with allegations. So again, in my submission, that would have to fairly be referring to the facts proven or the facts that are found that are relevant and of significant weight being taken forward in a risk assessment.
And the trouble is 23 uses the word concern in that very generic, we're all concerned type way, which again doesn't help at all.
Yes, and this is all, of course, under the heading an assessment of the level of concern. And so it's not the risk or the facts. And 24, again, there's some additions to 24. Mere allegations without any underlying factual basis or irrelevant allegations should be disregarded. So that appears to come from Morris.
What about the last sentence?
The last sentence appears to come from Pearce, paragraph 59, which is the panel's risk assessment should always be based on found fact, even if they're unable to make a finding of fact about all the matters.
Well, you wouldn't quarrel with that?
No, I don't. No. The problem is that in the context of how this is appearing, it is not undoing the damage of the confusion that's been sown, and that's the issue that I have. The addition of that and the earlier addition are welcome additions, in the sense that they are closer to the submissions, so the addition into paragraph 20 in the first part of it, but they don't remedy the structure that they're now in, or reflect what the legal principles would have required.
And the last sentence, the emphasis is on the word about all. Emphasis should be on the word all. I mean, it's just making the point. Make your risk assessment on found fact or facts, even if you can't make a finding of fact about all the matters raised. I mean, that's the only point it's trying to make, isn't it?
Yes, I mean, it's possible to read it as the correct reference to collateral facts being relevant and going through that process of building the blocks, but
it's just diluted by the I beg your pardon.
No, I'm sorry.
I'm terribly sorry.
No.
After you,
I'll give way to you.
Oh, well, it's just been diluted by the previous two sentences.
yes.
Yeah.
I mean, and what I was going to say is it goes back to Lord Justice Lewison's comment some time ago now, I think, about you have 5 facts. The fact you can take 1 to 4 into account, even though you may not be able to make a finding of fact about building block 5.
Yes. And there's no difficulty or confusion created about taking into account the facts 1 to 4 that you have. So I've covered the guidance there, and I perhaps don't need to say very much about the parole board decision, which is looked at in the judgment. Save that, which I've already mentioned. It doesn't, of course, when it's assessing the matters, look at the dates of matters or the relevance of them in that way, but I don't think the details of those are particularly good. There are 2 things that I haven't touched on, but I can do very briefly. One is the lawfulness of guidance legal tests. The case of A and the Secretary of State for the Home Department. You've seen my supplemental note in relation to that. I don't submit that there's any great change that's relevant to this case that comes from the re-endorsement of Gillick in that. So far as the grounds are concerned, I've set those 4 grounds out of appeal, rather. The appeal grounds at paragraph 17 of the skeleton. We've covered the failure to construe the guidance on allegations as being incompatible and inconsistent with the correct legal principles, and I rely on the submissions that I've made in relation to that. So far as ground 2, in the consideration of relevance, we've covered that in my submissions as to when it is appropriate to go into that approach. It's worth drawing to the court's attention that in the bundle of authorities at tab 24, I've included the lengthy article written by a member of the parole board and
Jeremy Roberts.
Crown Court Judge, Judge Jeremy Roberts QC, and he makes comments within that, and I won't now take the court to it, but about 3 points. One is the unusual facts and circumstances of war boys from the perception of a parole board experienced member. Secondly, the practice hitherto of the parole board as it reflects in experience before that. And thirdly, concerns over fairness that were raised in relation to the way in which that would operate. So it's perhaps useful to see some insight, as it were, into that. So far as the exceptionality point is concerned, I made the reference earlier to the psychologist's assessment and others in this particular case that had suggested it wouldn't change the risk factors that were set out in a lengthy way and had been being worked on in custody since his risk assessments were originally conducted years before.
So can we say exceptionality is relevance?
Yes,
Yeah.
yes. So it's really about where the relevance, how the understanding should be of relevance, I think. My lady's exposed the nomenclature doesn't help in a way. It's more that question. The fairness, the ground 3 failure to find that it was unfair of the board to decide the case on the basis of concerns without findings of fact, in my submission, largely follows from the legal approach that was required to be taken. And I've made some points about the process, firstly, and the fairness and the absence of things. And I've made points about the way in which it was dealt with by the panel on this occasion. I haven't mentioned the right against self-incrimination, bar, I think, in passing. Could I just make this reference to it? Because it hasn't yet, I think, been given much consideration in the authorities in this area.
Well, do you want to go here? Because in actual fact, as you now know, Mr. Orr, it's possible for adverse inferences to be drawn if people don't give an account of themselves in interview or don't give evidence at trial if there is a case to answer. So, I mean, it's not as simple as, a right against self-incrimination.
Well, my lady, I accept that point entirely, but what I would say about it is that was because statute interfered to remove the right. So what the Malik case, which we have in the bundle, is concerned with, previous cases that dealt with the 1994 Act that changed the adverse inferences. But the point about that is that the Parliament can, of course, abrogate the right, and it can decide that you don't have that right. But as a matter of common law, it exists before and otherwise. So the example of the example of the inquest rules, which are included in the skeleton, the Rule 22, which we have in the bundle of the Coroner's Inquest Rules 2013, was included because it states the point of the self-incrimination right in that context, which is one which is not determining civil or criminal liability, as we know, but could be assessing the consequences or causes of a death, and could be quite a serious inquiry, although all in serious inquiries, but it could be that the point that arises for this is a serious one in the context of an inquiry into death. And then Malone Jr. assisted with some research, was not implemented, as it were, by the Act, but it was common law before 1953 when the first rules adopted it. So its source, as it were, is the common law principles, and they in that case, at paragraph 73, there's reference to the fact that, of course, it can be abrogated. It hadn't been clearly by Parliament in Malik in terms of production orders that might expose you to prosecution for not having informed about a terrorist that the journalist had been dealing with. But it's relevant to note that the principle is recognised at common law as applying, subject to abrogation. So as far as we know at this point, there's been no statutory abrogation of the right in this context. And
but in any event, since you don't have to make an allegation or find an allegation rather than the building blocks, one of the building blocks could be we find that professed ignorance or professed amnesia is implausible. That's not an self-incrimination point.
That's absolutely right, but that is one of the points about putting the person on the spot with the obligation to answer or not. So in one of the cases that dealt with the CJPO 1994 silence changes, Smith, there was reference to the common law bases of the right to not self-incriminate, and one of them is that it gives a person a Hobson's choice. If you don't answer, you're in trouble, and if you do answer, you'll be prosecuted for what you've admitted. And whilst in some ways that might seem a perfectly appropriate situation, whilst the right applies, it is to prevent someone being placed in that position. And so the difficulty here, of course, is that if you're putting allegations to an individual, if they admit them, they are not given the immunity from prosecution, which often the law has provided where it removes the right to self-incrimination. So you do have that protection, that you could be honest about it, and it doesn't mean you're going to do another sentence having done 10 years of rehabilitation to get you to the point where you'll admit that previous matter. So it's not the mainstay of my case, as the court knows, but it's probably right, I hope, that I raise it, because it is a slightly thorny issue that has yet to be looked at, it seems, in this context.
My lords, my lady, I'm sorry to interrupt, but I just want to point out that it was also a point that was never raised in the High Court, so it's a new point as well. But I might
We'll bear that in mind. Thank you very much.
And the fourth ground is simply, as my lords and lady know, in relation to whether the test is a Wednesbury one or whether fair process requires a procedural fairness as a starting point. In my submission, Osborne, which you have in the authorities, is important to that and why fair process comes first, as it were. Unless there's anything that I can assist the court with in the minute that I'm overdue.
No, thank you very much, Mr. Rule. You're going to look at Read B.
We should, yes.
And the thought also occurred to me that one of the circumstances in which the court assesses risk is when it's thinking about granting a freezing order. It's looking at the risk of dissipation of assets. And it does so without making findings of fact.
My lord, I can certainly immediately riposte in the sense that is a very different context to deprivation of liberty. So I accept that.
Well, I just raised that.
I'll have a look, but my inclination is to immediately bat that one back if I may.
Right.
I hope with a racket it doesn't have a hold. But,
2 o'clock.
Court